Hello class, good day. How are you all doing? I hope you are all well, in good health and in good condition. Today we will discuss about some provisions under the Corporation Code of the Philippines. Now, the Corporation Code of the Philippines is Batas Pambansa Bilang 68. We have already finished the law on partnerships, and I hope you were able to understand what the law on partnerships is about. So if you have some clarifications, please do not be shy to ask some questions about our lesson. Okay? So if this is the Corporate Code of the Philippines, so Section 2 of the law provides that a corporation is an artificial being. What do you mean by artificial being? Now, we humans, we are naturally born. We are natural born because we are born from the wombs of our mom. It could be cesarean or via normal delivery, right? But when you say corporation, it is created by operation of law. That's why it's called artificial being. Corporation has the right of succession. Just like humans, whenever humans die, their successors, their compulsory heirs, would of course inherit their properties and even their debts. Okay, that's why when we say corporation, it also has the right of succession and the powers, attributes, and properties that are expressly authorized to them by law or incident to the corporation's existence. So the attributes, it is an artificial being, is created by operation of law. And just like as humans, it also has the right of succession, right to inherit those successors of the corporation. We also have the right to inherit the properties or even the debt, not the debt, D-E-B-T, debt of the corporation. Also, it has only the powers and attributes and properties that are expressly authorized to them by law or incident to the existence of the corporations. Now, we are already finished with our partnership, and some of you, my dear students, ask me, what's the difference between partnership and corporation, ma'am? Actually, they're almost the same. At first glance, they were almost the same, but actually, they're not the same. They only have similarities. So what are the similarities between a partnership and a corporation? These are as follows. So we have one, it has a juridical personality separate and distinct from the individuals composing it. So just like the partnership, a corporation also has a separate personality, juridical personality, which is distinct from the individuals composing the corporation. Just like partnership, di ba? You have partners A, partner B, and partner C. So A, B, C, and then they form the corporation is the fourth member of the band of the partnership. So the ABC partnership is not the same as A only, is not the same as B only, is not the same as C only. The same with corporation. The incorporators of the corporation have separate personality from each other. Second, in partnership, the partnership acts only through its agents. Same with partnership, also the corporation acts through its agents. Third similarity is composed of an aggregate individual. So there are individuals composing the corporation. So we will discuss later how many individuals should comprise a corporation. But new law, which I will discuss later relative to corporation. So the fourth similarity between partnership and corporation is that it distributes profits to those who contribute to the capital. Only those who contribute capital, mean to say money, cash, to the common fund. For example, common fund in the partnership and the fund of the corporation will have this right to receive the profits. And also, another similarity between the two is that these two may be organized only when there is a law authorizing it. Because if there's no law, for example, there's no law on partnership, there's no law on corporation, then it cannot be created or organized. Partnership and corporation are subject to income tax. Why? Because these two are created. Of course, the purpose is to earn profits, derive profits. And when you say profits, it's income. When there's income, this income must be taxed. So, pwede na natin ma-evade yung lahat, wag lang itong tax. So we have the distinctions between partnership and corporation. What are the distinctions? What's the difference between the two? So we have this point of comparison found in the first column. So here we have the manner of creation. So when you say partnership, by mere agreement of the parties. But for corporation, it must be by law or operation of law. There must be a law that would authorize the organization or creation of the corporation. Point of comparison again, number of parties. In partnership, the minimum is at least 2 persons. In corporation, it requires at least 5 incorporators, but later I will discuss another law does not have this kind of requirement, 5 incorporators. Then the third point of comparison is on commencement, pagsugod, pagsimula of the juridical personality. When the juridical personality starts. In partnership, it generally attains juridical personality the moment that the contract of partnership, which we already know as the article of partnership, the moment that the partners executed that article of partnership, that juridical personality is already there. But in corporation, from the date of issuance of the Certificate of Incorporation of the Securities and Exchange Commission. So, in partnership, there is no need for the articles of partnership to be registered in the SEC. But there's a provision found in the law of partnership where the SEC is necessary. Okay, when the amount is at least 3,000, the capital contribution is at least 3,000 pesos, right? Incorporation, from the date of issuance of the Certificate of Incorporation of the SEC. The juridical personality of the corporation cannot be assumed the moment that they executed the articles of incorporation. No. It only assumes existence or juridical personality upon the issuance of that certificate of incorporation. And who or what particular agency would issue the certificate of incorporation? It is none other than the SEC, or the Securities and Exchange Commission. Powers. Now, in partnership, the partnership may exercise powers authorized by partners, provided the same are not contrary to law, morals, good customs, public policy, or public order. Now, in corporations, they can only exercise the powers expressly granted to the corporation, by law or incident to its existence. There must be a law that authorizes the partnership to go into mining, for example. Okay? There must be a law that authorizes them. Then another point of distinction between the two, partnership and corporation, is on the management. In partnership, when it is not agreed upon, each partner is an agent of the partnership. In corporation, it is vested in the BOD or BOT, the board of directors or trustees. Now, the management of the corporation cannot just be simply given to a particular person in the corporation who is not part of the board of directors or trustees. Right of succession. Now, in partnership, there's no right of succession, but in corporation, it has the right of succession. Again, I already mentioned this earlier. Corporation is just like human beings, only that it is artificially made by operation of law. When you say artificial, it is not like human, born from the wombs of the mother, but it has the right of succession. Because when the corporation ends, there's always the successor of the corporation will have these properties, even debts of the corporation. So just like humans, when our mother or father, for example, they die, whether testate or intestate, their properties will be inherited by the children or the compulsory heir. So the corporation also has that right of succession. The extent of liability to third persons. In partnership, except for limited partners, the partners in partnership are liable personally and subsidiarily for partnership debts to the third persons. In corporation, they are only liable, the stockholders are liable only to the extent of their investment as represented by the shares subscribed to them. Now, the next distinction between partnership and corporation is on the transferability of interest. In partnership, a partner cannot transfer interest so as to make a partner without the consent of all the existing partners because of delictus personae. You cannot insist that a person become a partner to the partnership without the consent of the other partners. And then we have here for corporation, on transferability of interest, a stockholder has the right to transfer his share, even without the consent of the other stockholders. In partnership again, you cannot transfer your interest to another person to make that other person be a partner to the partnership without the consent of the existing, because that is already a violation. Then we have here term of existence. So when you say term of existence in partnership, it may be established for any period of time stipulated by the partners. As long as it is indicated in the AOP, articles of partnership, when it could be established, they can actually stick to that particular stipulation. But in corporation, it may not be formed for a term in excess of 50 years, extendable to not more than 50 years. So they can, in partnership, they may be established for any period of time, right? As long as it is stipulated or agreed upon by the partners. Firm name. Firm name. So in limited partnership, there's a requirement that you add the word LTD to the name of the partnership. In corporation, you may adopt a firm name provided it is not identical or deceptively similar to any registered firm name or contrary to existing laws, because when you try to register your corporation before the SEC, you need to submit several documents, and of course even the name. They will check if there's an existing name, your name would be duplicitous, and they would not allow you to use that particular firm name. So you have to choose another firm name for your corporation, if that's the case. On dissolution, in partnership, it may be dissolved at any time by the will of any or all of its partners. But in corporation, it may only be dissolved with the consent of the state. Why is this so? Because there are instances when the incorporators or even stockholders, they would just dissolve the corporation to evade their obligations. Corporation actually have applied to the terms and conditions provided before you register your corporation before the SEC. Governing laws. For partnership, it's under the civil code. For corporation, of course, there's the law on corporations or the corporate. What are the advantages of a corporate form of business? So this is one thing that you have to pay extra attention, because this would come up. Advantages of corporate form of business organizations, and you need to elaborate your answer. So number one is on the capacity to hold property, to contract, to sue, and be sued as a legal unit or distinct entity. This is the advantage of corporate form, because you can sue and be sued as a corporation. There are some people who would say, we would just form a corporation so that we can do those ultra vires acts. Later we will discuss ultra vires acts. So, or you would commit estafa, you would lure people, you would cause some deception to the public. So the corporation can be sued, and it can also sue as a legal unit or distinct entity. The second advantage is exemption of shareholders from individual liability, because there is separate and distinct personality of the corporation from its incorporators. Then continuity of existence in spite of death or changes of members, because in partnership, when a member dies, for example, they can just end there. They can end the partnership, or they can continue the partnership, but there are some terms that they have to comply. But in corporation, even if the main incorporator dies, they can still continue the existence of the corporation in spite of death or changes of its members, because they can sell their share to other people even without the consent of the other incorporator. So we have here transferability of shares. This was already discussed earlier. Centralized management under a board of directors or trustees. And then standardized methods of organization, management, and finance for the protection of shareholders and creditors under statutory regulations. So these are the advantages. You have to take note on this, because this would come up in our quiz. And then, of course, we have disadvantages. The disadvantages of a corporate form of business organizations: the limited liability of stockholders. So it serves to limit the credit available to the corporation, because when you have, for example, this is your capital, this is the only capital that you have for your corporation, it would limit the credit line that would be available to the corporation. Then transferability of shares permits the uniting of incompatible and conflicting interests in one enterprise. Have you heard of some people say that there were big names in big corporations like ABS-CBN, stockholders of ABS-CBN, who are actually GMA artists? Do you know that? They are stockholders of ABS-CBN shares. Not because they like the cost of ABS-CBN or etc., but mainly because of monetary reasons. Also, there are some people who would buy shares, PAL shares, for example, Philippine Airlines shares, not because they believe that PAL is the best airline, but because they believe that it offers great shares for them. Or San Miguel Corporation. So there's no necessity that those people who are stockholders or shareholders in the corporation, they have unity in interest, or even in a particular enterprise. The third disadvantage is that the minority stockholders are usually subservient to the wishes of the majority. You will learn later why, because those in the majority, from the term itself, from the word itself, majority, they are the ones who would hold. They would be the ones who would have the biggest say in the corporation, and those minority stockholders will just simply listen to them, and they would just say, okay, if that is your wish, since you are the majority, then we would just accept that. They had no choice. That's the disadvantage of a corporate form of business organization. And then we have in big corporations, the stockholders' voting rights have become largely theoretical because of widespread ownership, disinterest in management, and inaccessible meeting place in early days or before. But now, because of the advent of technology like online, virtual conferences, I don't think this is an disadvantage anymore. In large corporations, management and control has been separated from ownership. Yes, it's like for example, Henry C. SM Holdings is not the one who reads or manages the corporation, or even Facebook, for example, the corporation of Google. The holders of those corporations, they are not the ones who truly or really manage their corporations. There are other people who manage the corporations or even their enterprises for them. And then by and large, corporations are subject to governmental restrictions, controls, and the reportorial requirements that impose on other forms of business organizations. They need to submit all of those requirements, otherwise they would be penalized. Corporate sphere of activity is limited in the transaction of its business to the state of organization. Its businesses should adhere to the terms and conditions that are given to them, imposed upon them by, of course, the SEC. If they violate those terms and conditions, then they would be penalized. Corporate form involves double taxation on corporation income. In corporation income, they say, remember Manny Pacquiao? He said that if only corporate taxes would be cut, more businesses, big corporations would be enticed to invest in our country. But there would be a huge debate on this because when you say taxation, since it is the lifeblood of the country, as much as possible, these big corporations must be taxed based on the income that they derive from their businesses. For them, for these tax people in the BIR, Bureau of Internal Revenue, under or pursuant to the NIRC, what they're doing taxing all these corporations is actually our legitimate exercise to regulate the businesses. When you are asked to discuss the disadvantages of a corporate form of business organizations, just cite at least three and then in your own words. Don't copy. So classes of corporations, these are found under section 3 of the Corpo Code. The corporations formed or organized under the Corpo Code may be stock or non-stock corporations. Those which have capital stock divided into shares and are authorized to distribute to the holders of such shares dividends or allotments of the surplus profits, and the basis of dividend would be the shares of these stockholders which are held by these stock corporations. All other corporations are non-stock corporations. So the key words here for corporations is the division of or distribution of dividends. Distribution of dividends to the shareholders. If the corporation does not have this characteristic of distributing dividends to the shareholders, then they are considered as non-stock corporations. So other kinds of corporations, we have quasi-corporations from the word quasi meaning murag-murag, as if, are entities that are not absolutely corporations but are considered as corporations, as if they were. Example are public boards created by law. Dili na sila private corporations. Quasi-public are entities engaged in rendering basic services as to entitle them to certain privileges. For example, for electric, gas, water, telephone companies, these are quasi-public. Then we have GOCCs. What are the examples of GOCCs? We have GSIS, okay, PhilHealth, so NPC, NAPOCOR. So these are government-owned and controlled corporations. They are corporations of which the government is a majority stockholder. Even Philippine Airlines is before actually it's a government-owned and controlled corporation, but now it's already a privately owned corporation. So GOCCs are PhilHealth, GSIS, NAPOCOR, those entities where the government is a majority stockholder. Domestic, one incorporated under Philippine laws. If foreign, of course, they are formed, organized, or existing under foreign laws other than those of the Philippine law. So the sixth kind of corporation is what we call the corporation aggregate. It is that kind of corporation composed of more than one member or incorporator And then we have corporation sole. So corporation sole consists of one member or one incorporator and his successors. Corporation sole. And then we have the religious corporations. These are called sole or aggregate. They are organized either as sole or aggregate. For example, is Santo Papa in Rome, considered as corporation sole. And then ecclesiastical, organized for religious purposes. As long as it's organized for religious purpose, that's and it is a corporation, it is ecclesiastical. Maybe the one by Kibuloy is that a corporation? If it is a corporation, then it is ecclesiastical. Then we have lay. It's organized for a purpose other than religious. Read this one and then you will have an idea what are those kinds of corporation. But we will not talk about these corporations that are organized for religious purposes. We would be focused on those that are material to our understanding of corporation. What are those? Public corporation. We won't discuss public corporation. That would be discussed when you go to or proceed to law. So we will just discuss the stock and non-stock corporations, the basics. And we have non-profit. These are organized without contemplation of gains, profits, or dividends to their members on invested capital. So their main purpose is to charitable institutions, for example. The YURI is one created in strict or substantial conformity with the statutory requirements for incorporation and whose right to exist as a corporation cannot be successfully attacked. So that's the YURI. The one is de facto. So de facto is does not follow what is provided under the rules. But if it follows the rules and the law, then it is de jure. Okay, so it cannot be successfully attacked even in a direct proceeding. Please note on the difference between de jure and de facto corporation. Corporators and incorporators, stockholders and members. So when you say are those who compose a corporation, whether stockholders or members, and the incorporators are the stockholders or members mentioned in the AI articles of incorporation. They are the ones who originally formed the corporation and they compose the corporation. They are likewise the signatories of the AI or articles of incorporation, which is registered under the corporators, incorporators, stockholders, and members. Second, corporators in a stock corporation are called stockholders or shareholders. So in a non-stock corporation, they are simply called members. They are called stockholders. The corporators are called stockholders or shareholders because they have this right to receive dividends. For corporations that are deemed as non-stock, corporators are called members only because they don't receive any dividends or profits. So components of corporation, so these are the components, the corporators, incorporators, stockholders, members. So they are the ones who consist or compose the corporation. Promoters, so promoters. When you say promoters, these are those people who are constituted organizers and they find enterprise or venture and they help to attract investors. From the word promote, they promote the corporation to attract investors. They form a corporation and launch it in business with a view to promote profit. Okay, that's the end goal of promoters. Members, corporators in a non-stock corporation. Stockholders, corporators in a stock corporation. Promotion is the act of procuring initial finances and the making of all preparations that are necessary to launch a corporation. General rule, a corporation is not bound by any agreement made by a promoter. The exception to this is unless and until the corporation approves the agreement. So for example, there's a promoter and then that promoter gave this proposal to the corporations, to the majority stockholders, for example. So there was no actual express consent or goes from the majority stockholders. And then the promoter just executed what was stipulated in the proposal. The act of promoter be tied up to the corporation? Yes or no? Please think about that. That would come out in our quiz. And then give your reason. Section 6, classification of shares. The shares of stock corporations may be divided into classes or series of shares, or both. So we have here provided that no share may be deprived of voting rights, except those classified and issued as preferred or redeemable shares. Another provision provided further that there will always be a class or series of shares which have complete voting rights. So, kani siya, gistorya ta dinhi, we are talking of the voting rights of those stockholders. So, under Section 6, it talks about classification of shares. So, the classification of shares, it says here that the shares of stock corporations may be divided into classes or series of shares, or it could be both. Of the shares may have rights, privileges, and restrictions must be stated in the articles of incorporation. For those who are shareholders, for example, they need to see to it that their rights, privilege, and restrictions are there in the articles of incorporation. And there is this provision that in the articles of incorporation, no share, okay, may be deprived of voting rights except those shares that are deemed as or classified as preferred or redeemable shares, provided further that there shall always be series of shares or class of shares which have complete voting rights. Any or all of the shares or series of shares may have a par value. So, ang shares ninyo class, di ba naman na sila mga shares? We're talking of stock corporations because we're talking of shares. So, this is not applicable non-stock corporation because in non-stock corporation, there are no shares to talk about. So, in this particular section, it talks about the shares of stockholders, wherein it states that the shares may have par value or no par value as long as these are provided for in the articles of incorporation. No share will be deprived of voting rights except those preferred or redeemable shares. That are classified as preferred or redeemable shares may be deprived of voting rights unless there is a provision shares having par value or no par value are indicated in the articles of incorporation. When we talk of banks, corporations that are banks, trust companies, insurance companies, public utilities, building, loan, they shall not be permitted to issue no par value shares of stock. Why? Because they are actually using all this capital of the stockholders. So why is it that it has no par value? Why is it that it has no value, right? So they must issue only shares that has par value when they are banks, they are trust companies, insurance companies, public utilities. There are stock corporations, okay, stock corporations that issue shares, but they have no par value, okay? You have to bear that in mind. Preferred shares of stock issued by any corporation may be given preference in the distribution of the assets of the corporation in case of liquidation and in the distribution of dividends. So preferred shares issued by corporation, they from the term preferred, they are given preference in the distribution of assets of the corporation and even in the liquidation. So this must be other preferences as may be stated in the articles of incorporation that are not violative of this particular law, provided that preferred shares of stocks, those preferred shares of stock may be issued only with a stated par value. Dili pwede nga mosulti sila no par value ang share of stock aning mga preferred shares. Kay balin-balin magud ani mo class. The board of directors were authorized in the articles of incorporation. They may fix the terms. The board of directors, if they are authorized in the AI articles of incorporation, they may fix the terms and conditions of the preferred shares of stock. But they have to bear in mind that such terms and conditions which they would amend, or the terms and conditions that these incorporators would change or amend, shall be effective upon the filing of a certificate thereof with the Securities and Exchange Commission. If the incorporators are going, or the board of directors are going to change the TC, terms and conditions, as regards the preferred shares of stock or any series thereof, they need to file this change of certificate with the Securities and Exchange Commission. Absent, or if they were not able to file that certificate with the Securities and Exchange Commission as to the change or amendment on the terms and conditions, then what would happen? It will not be effective. Shares of stock, capital stock issued without par value shall be deemed fully paid, and they are non-assessable. And the holder of such shares, so no par value niya, no par value. If the capital stock is without or no par value, they are deemed fully paid, and they are non-assessable. Dili na nimo kailangan na siya i-assess. No need for assessment. And the holder of such shares shall not be liable to the corporation. So if the corporation would become indebted to another person or even another corporation later on, the stockholder, shareholder of such non-par value will not be liable to the corporation or to the creditors of the corporation, provided that the shares, those shares without par value may not be issued for a consideration less than value of 5 pesos per share. So the minimum value for a non-par value that may be issued for a consideration, if you're gonna sell it, for example, your non-par value share, you're going to sell it, it must be at least 5 pesos per share. Another provision, provided further, mo siya makabuang sa corporation class, kaya sila provided further, bet kay sila Marcos, that the entire consideration received by the corporation for its no par value shares shall be treated as capital. So, capital siya and not available for distribution as dividends. So, because how can you distribute it as dividends when it has no value in the first place? So, you can only distribute dividends if the shares has par value. Unsa man gud ning par value, ma'am? It is the nominal value of a bond, share of stock, or it refers to a coupon as indicated in the writing on the document or specified by a charter. In simpler terms, it is the face value of a bond. So, par value is important for a bond or fixed income instrument because it determines its maturity value as well as, for example, the dollar value of coupon payments. The whole gid ang value kasagara sa share. So, there would be some 100 per share, di ba? If the value of the share is that it has a par value, then it can be later on when the corporation gain profits for its business, then it can distribute dividends. So a corporation may further classify its shares for the purpose of ensuring compliance with constitutional or legal requirements. So, except as otherwise provided in the AI and stated in the certificate of stock, because when you become a stockholder or shareholder, you buy, for example, one share and the value of the share at the moment. If you are a shareholder, for example, of San Miguel or Ayala group of companies, if you are a shareholder of the Ayala's companies or SME, for example, and the value of a share is 100,000 pesos. You buy one share, so you pay 100,000 for one share, and then they would issue you a certificate of stock. Each share shall be equal in all respects to every other share. So it would be indicated in the certificate of stock the value of the stock that you just paid for. So where the articles of incorporation provide for non-voting shares in the cases allowed by this code, the holders of such shares, you are the holder of the share. You have the certificate of stock as an evidence that you are a shareholder. So the holders of such shares shall nevertheless be entitled to vote. So you can vote in the following matters. So what are those matters where you as a shareholder, because you have a certificate of stock for everyone to see, okay, I'm a shareholder of SMC, I have the certificate of stock, so I can do this thing. So what are those things that you are entitled to vote on? 1, amendment of the Articles of Incorporation. C, you can have a voice on the amendment of the AI. Second is adoption and amendment of bylaws, because aside from the Articles of Incorporation, you also need to register the bylaws of the corporation with the SEC, Securities and Exchange Commission. Another matter wherein you are entitled to vote as a shareholder is sale. On sale, lease, exchange, mortgage, pledge, or any disposition of all or substantially all of the corporate property. So when you say there would be at least a sale, I am not in favor to sell this particular property of the corporation because of so and so and so and so. So you can have that voice. You can have that voice in the corporation. And then incurring, creating, or increasing bonded indebtedness, because in businesses, we have to admit that you cannot use your personal money in operating a business. Most of the businessmen would say that for them to grow as a business, they need to borrow money. So how do you do this? Of course, you have to borrow money from funding sources, from banks, from financing institutions. So you would increase your indebtedness. So for corporations, they also have this matter of on incurring, creating, or increasing the bonded indebtedness of the corporation. So you have a say on this. You would say, no, I'm not for this particular proposal to increase our indebtedness, bonded indebtedness, because so and so and so and so. Another matter wherein you also have a voice to vote Okay, increase or decrease of capital stock, because I don't want to increase the capital stock, I just want to maintain this one, and then you give your reason. Then merger or consolidation of the corporation with another corporation or other corporation. No, I don't want our corporation to be consolidated with another corporation because so and so. If you're gonna merge it, consolidate it, I'm gonna sell my share. So that would be another matter wherein you also have a voice as a shareholder of the corporation. Investment of corporate funds in another corporation or business in accordance with this code. So every time that there are some moves or actions that need the approval, of course, of the shareholders, the secretary would announce to the members that, hey, this is the agenda and we will tackle all of these. What are your thoughts on this? We would vote on this. So you would be apprised on what would happen to meetings of the corporation. So have here definition of stock. Okay, you just have to read on that. Except as, of course, the dissolution of corporation. Except as provided in the immediately preceding paragraph, the vote necessary to approve a particular corporate act as provided in this code shall be deemed to refer only to stocks with voting rights. If you have no if you are a stockholder with no voting rights, of course you cannot vote. Obvious ba? So definition is stock or share of stock. So is one of the units into which a capital stock has been divided. It represents the interest or right that the holder of a stock or stockholder has in a corporation. So please remember this. Then you have to distinguish stock from stock certificate, of course, in your own words. So this is a certificate wherein it is indicated therein a holder or owner of a certain number of shares of stock in the corporation. And it is a documentary evidence. Again, this is the certificate that will be issued to you as a stockholder or shareholder. Then classes or series of shares of stock subject to restrictions. So we have here number one, shares shall not be deprived of voting rights except the preferred or redeemable shares. So what are those shares that are deprived of voting rights? The preferred or redeemable shares. But non-voting shares must still be entitled to vote. Non-voting shares must still be entitled to vote on matters specified in the last paragraph of Section 6. For example, matters that relate to the amendment of the Articles of Incorporation and dissolution of incorporation, because these are very critical not only to those who have voting rights, but to all members or to all stockholders. Where non-voting shares are provided for, there must always be a class or series of shares with complete voting rights. So they must indicate there the complete voting rights of the shareholders. Banks, trust companies, insurance companies, public utilities, building loans, etc., shall not be permitted to issue now par value shares of stock. So this number 3 you also have to bear in mind because it would also come out in the quiz. Banks, trust companies, insurance companies, public utilities shall not be permitted to issue no par value shares. Preferred shares of stock which may be given preference in the distribution of assets in case of liquidation, and distribution of dividends, or other preferences may be issued only with stated par value. You must indicate therein the value, okay, value of that share, the par value of the share. Terms and conditions of preferred shares or series thereof may be fixed by the board of directors only when they are authorized by the AI. If they are not authorized, there's no specific or there's no express provision in the AI that this board of directors are authorized to fix those terms as regards the shares or series of shares, then that act of the the board of directors would be invalid. They have no effect to the corporation shares. Okay, they shall, and also those terms and conditions shall be reckoned only from the filing of the certificate of such amendment with the SEC. Shares without par value may not be issued for a consideration less than the value of 5 pesos. So these are actually the learnings for this particular topic. Article found in this site ndvlaw.com, a guide on one-person corporations in the Philippines. So it says here forming one-person corporations in the Philippines. This is already applicable now. We can have one-person corporation here in the Philippines. So as I mentioned earlier, when we talk of corporation, we need at least five people to form the corporation. But this is no longer applicable now. You can already form your corporation, one-person corporation. And the purpose actually is to streamline the requirement. But here are the following things that you need to understand when we talk of one-person corporation. When we talk of OPC, one-person corporation, it may be formed in the Philippines but it is composed of a single stockholder. And that single stockholder can only be a natural person. Natural person, it could be a trust or it could be an estate. Only one, okay? If it is a person, it could be a natural person or it could be a trust or estate. Ma'am, saan ang trust or estate? Estate of kanang mga properties, involving the properties of a dead person, for example. Its term of existence is perpetual. Perpetual, hantod sa hantod na siya. But in case of a trust or estate, the term shall be coterminous with the existence of the trust or estate. Why, ma'am? Di ba patay naman na? Yes, for example, sa estate, so patay naman na siya. But later on, for the compulsory heirs, for example, kana mga heirs nga nabilin kana sila, they would divide the estate. So they would have this extrajudicial settlement of estates. They have this. They already executed the extrajudicial settlement of estate. Mawala na si estate. So ang life ana sa one-person corporation would end there once these heirs would execute that document or that extrajudicial settlement of estate. So end ng estate. So it should be the term then when it talk of estate or trust it is coterminous with the existence of the trust or estate. The suffix OPC must be indicated in the corporate name so that the person, all of us would be apprised that that particular corporation is a one-person corporation. So for example, lalo na OPC. So it's a one-person corporation. So the following are not allowed to form an OPC. What are those that are not allowed to form an OPC? Please take note on this. Bank, non-bank financial institutions, quasi-banks, pre-need trust, insurance companies, public and publicly listed companies, non-chartered GOCCs. So kung you say non-chartered, wala sila'y balaod, no? A natural person licensed to exercise a profession for purposes of exercising his or her profession. So, like example sa ako, abogado man ka, ma'am. Okay, pwede ba ka one-person corporation? Dili. Because I am licensed to exercise my profession as a lawyer, as an attorney. So, dili ko pwede aning one-person corporation. It must be noted that a foreign natural person can set up an OPC. So, kanang mga foreigners ng mga friends, they can actually set up their OPC subject to applicable capital requirements and constitutional and statutory restrictions in investment area. Nana sila list latest sa Philippine Investment Negative List to view the applicable capitalization. So, the powers of a sole director, ikaw ra in an OPC. Ikaw ra ang director, ikaw ang corporate, so ikaw na tanan. So the difference ani ma'am, di ba naman tayo single proprietorship? Yes, but later on we will discuss why this is better than the single proprietorship. So in the single stockholder shall be the sole director and president of the OPC. So within 15 days from the issuance of the certificate of incorporation, the OPC, the one-person corporation, shall appoint, na daw siya, appoint siya. Ma'am, kanang treasurer, corporate secretary, and other officers, siya rin po na, dili. Not necessarily, because they are not members actually of the OPC. So, he would just appoint the treasurer. Of course, he is not the treasurer, he is not the corporate secretary and officers, maral po siyang buang. So, he shall appoint these persons, these people, treasurer, corporate secretary, and other officers, or under him. Okay, the SEC must likewise be notified of such appointment within 5 days therefrom, so that the SEC would be apprised. Oh, so here are your officers, here are your treasurer, corporate secretary, etc. So the single stockholder cannot be appointed as corporate secretary, but he can also be a treasurer. So the single stockholder cannot be appointed as corporate secretary, but he can be a treasurer. If he is concurrently the treasurer, he must post a bond based on the authorized capital stock of the OPC as shown in the table below. The bond is a continuing requirement so long as the single stockholder is the treasurer. If he is not the treasurer, then there's no need for him to post this bond. To post the bond based on the authorized capital stock. Why? Pwede man gud kay dagan niya, pwede man gud nga manlinlang siya. Pwede kasi na manlinlang siya o magiging mandaramong siya, magiging fraudulent yung mga acts niya as a treasurer, and at the same time the single stockholder, at the same time the sole director in an OP. So what are then? So again, this is subject to renewal every 2 years. The appointment is subject to renewal every 2 years. So the authorized capital stock in the Philippines. The renewal of appointment of the corporate secretary, of the treasurer is every 2 years. Pwede kasi na later yung corporate secretary nag-resign na siya, or yung treasurer, ikaw na single stockholder at the same time sole director of your one-person corporation, nagsawa ka na maging treasurer, ayaw mo na kasi sakit sa ulo yung mga numero na yan. So, you would renew the appointment every 2 years. So, authorized capital stock in the Philippines. So, if you are the single stockholder, okay, sole director in your OPC, so what is that particular bond that you have to post as single stockholder at the same time treasurer? So, if the capital stock ACS authorized capital stock is 1 to 1 million, it would be 1 million also. Okay, surety bond coverage. And then, if more than that, up to 2 million, 2 million din. So, same amount. Naginana pa ka, no? So, kung ano yung pinakamalaki, whatever would be the highest in this particular range, the highest capital stock, that is also the surety bond coverage. Single stockholder shall also designate his nominee and alternate nominee. If the single stockholder becomes incapacitated by reason of physical impairment, becomes incapacitated physically, then the nominee can take over the management as director and as president for and in behalf of that one-person corporator. Should the single stockholder die, if the single stockholder die, then the nominee temporarily takes over until the legal heirs, successors na, the legal heirs of the former have legally determined who will take the place of the deceased. Because remember, in corporation, we have the rights of succession. In OPC, in one-person corporation, if that single stockholder dies, then the nominee will temporarily take over the management of the OPC, become the director, president, OIC of the OPC, until the legal heirs of the single stockholder who is now dead have legally determined who will take place of the deed. So what are the reportorial requirements of an OPC? So here are the following that the OPC must comply. Annual audited financial statements must be submitted to the SEC within 120 days or almost 4 months from the end of its fiscal year. A report on the comments by the president, so that would be him, the single stockholder, on the adverse remarks made by the auditor in the financial statements, if there is. And then a disclosure of all self-dealing and related parties transactions entered between the OPC and the single stockholder. Because again, the OPC, even if he is also the single stockholder, they would have different, separate juridical personality and other reports as may be required by this. Okay, that would be it. If you have questions, class, do not think twice of sending your comments or messages in our Google Classroom or even in our Job Messenger group chat. If you don't have any questions, then I presume that all of you have understood the reading materials, the assigned materials, as well as this video discussion. So that would be all. Thank you very much, and I hope that you learn, my dear students. God bless us all. Good night.